Mr. Lefcourt, thanks so much for agreeing to do this.
Well, happy to be here.
I want to talk to you about, well, your work, your entry into the legal profession. Why law? Why criminal law?
Well, I was interested in business actually in college and worked in a banquet department of a hotel pretty much full time while attending college. And I continued that after I decided law school would help my ideas about going into business. But once in law school, things changed radically after I got an internship at the Legal Aid Society.
What did you see there?
What I saw was a broken system, terrible for defendants, overwhelming unfairness and injustice. I, as a law student, was assigned to a legal aid lawyer who had as many as 200 cases on his calendar. He couldn't do more than just say, hearing, trial, guilty plea. And he would have me go into the pens and interview his clients who he didn't have time to speak to. It was just a bizarre joke. And I couldn't sleep thinking about it. And suddenly it changed my whole perspective on my life. And what I wanted to do was change that system.
And when was this?
This was in 1968, 67. When I graduated law school, I went and got a job as a legal aid lawyer. And almost immediately, I started organizing a union of lawyers. That union was formed, and it radically changed the Legal Aid Society of New York, which I was very proud of. It didn't help a lot of other places in the country, but it was a start. And I guess I've spent most of my non-case life trying to professionalize the defense function. I was the founder of the New York Criminal Bar Association with others. I was a founder of the New York State Association of Criminal Defense Lawyers. I was president of the National Association of Criminal Defense Lawyers, and I started a foundation for criminal justice, which is now operated by National Association of Criminal Defense Lawyers. So I spent the last 45 years trying to make the defense function important and relevant, well-funded, and effective.
Have public defenders' offices changed over the years? In other words, public defenders get a bad reputation, but really they're good lawyers who happen to be oftentimes overwhelmed with caseloads and lack of funding. Do you think that public defenders sometimes get a bad reputation because of those things?
Of course, everybody hates the defense function, other than defense lawyers. Prosecutors hate us. The judges who are former prosecutors pretty much are on the side of the prosecution. The public says, how could you represent those evil people? Nobody likes us.
Now, many defense lawyers do prosecution work first. You didn't want to do that at all.
I'm pure.
What do you mean?
I was never attracted to the prosecution function. And, they have such advantages. I have many mentors, but one of them, William Kunstler, who I was in the Chicago 8 case with, pointed out so much inequity. Donald Trump runs around saying the system was rigged against him. He's right. And so is Joe Biden's son. The system was rigged against him. Prosecutions have advantages that the public doesn't see.
I want to talk to you about some of those cases, actually, now that you brought that up. This whole idea that political prosecutions exist in this country is so foreign to most folks living here. Whether or not it's true or untrue, how difficult is it? How burdensome is it for our society to think that these things even exist?
Political prosecutions have always existed. I mean, I was in the Chicago 8 case. What was that? That was a conspiracy to disrupt the Democratic Convention in 1968. The 8 defendants, a few of them knew each other. Most of them didn't know each other, had no involvement with each other, but were joined together because Richard Nixon wanted to go after the anti-war and civil rights movement, and he prosecuted them in a totally political way. As the then Attorney General, Ramsey Clark, who was the previous Attorney General before the Chicago 8 were indicted, testified during a hearing in the federal court. This was very political, and it really came on the heels of a hearing at the House Un-American Activities Committee in DC, who subpoenaed these very future defendants and brought them into a hearing and attacked them as being socialists or what have you, picked up on by Nixon's Attorney General, and they were indicted during the Nixon administration. Very political.
Are appellate courts, is the appellate system a useful weight against those kinds of things?
It all depends who's sitting there when. I mean, let's face it, what we're witnessing with the Supreme Court of the United States and how the court was packed by right-wing people who advocated for certain justices. Trump appointed them. The Senate confirmed them, and now you see what you got. They told the Senate about Roe v. Wade, it's precedent. There were no, all of them didn't suggest that they would run in there and overturn it immediately. They were misrepresenting their positions before the Senate.
I want to talk to you about trial work a bit. I don't mean to age you, but you began trying cases in the 70s and the 80s. It seems that less cases are being tried these days. Why is that? Is the government getting better? Is it just harder to defend cases at trial? The sentencing guidelines, some combination of those things?
It is a combination of all those things. And the federal system, the sentencing guidelines are a powerful incentive to work out a plea agreement. Prosecutor essentially says to you, you know what, we can enter into a plea agreement where you have a chance of probation, but if you insist on going to trial, we're going to look at this and look at that, and you're going to end up facing a guideline range of 5 to 7 years. Now, most defendants cave under that kind of pressure. You have to be very strong and very convinced of your position. This is not a secret. Everybody who works in the federal criminal justice system knows that to be the case.
How has New York City changed over the years in terms of policing, prosecutorial misconduct? Has it changed in the years and decades prior?
Yes, I think there is a greater recognition of the harm that prosecutors do with certain of their tactics, such as failing to disclose exculpatory material, failure to give early discovery. I mean, if you think about it, why should it be so narrow and so difficult for the defense to be in an equal position as prosecutors? The Southern District of New York has the FBI, the IRS, all the federal agencies to help prepare a case. What does a defense lawyer have? He has, somebody probably can't afford to pay the defense lawyer. Forget about investigators and, launching into the kind of investigation that prosecutors could do. Prosecutors don't share the product of that investigation. They give you the prior statements of the witnesses that they're going to call. They'll give you the documents that they intend to introduce. But the product of that investigation, which a defense lawyer, if the defense lawyer had access to it, could use it very effectively during the trial to cross-examine, even to call witnesses that they're not aware of.
So much of that falls on the shoulders of what they call prosecutorial discretion, right? This idea that prosecutors have ability to make judgment calls based on subjective factors with virtually no oversight. Do you see that as a problem? And if so, is there any way to fix it? Or is it so ingrained in our system that we just have to kind of go along with it?
Well, it has to do with who's in power politically. The New York State legislature a few years ago did make discovery reforms. New York, notwithstanding its so-called liberal status, was one of the worst states in the country in terms of discovery for defendants in criminal cases. And it took a change in the legislature for there to be progress. I mean, you can't imagine the number of decisions where cases were reversed because of prosecutorial misconduct, but nothing changed. I mean, if there is a reversal because of prosecutorial misconduct, the prosecutors should look into that, change things. No prosecutors are ever disciplined for failing to disclose information. I'm not aware of prosecutors being, put before the bar, the, disciplinary committee for failing to disclose, important information. Nothing ever happens. And so it really takes a concerted effort, the change of the representation in the Senate and the Assembly, as well as the governor.
Several years back, maybe a decade or so, there was a spike in wrongful conviction cases, 440 motions, things of that nature. Has policing changed since the 80s and 90s? If so, how?
Well, the problem of a lack of trials really, hurts the ability to have better policing. If police, detectives, law enforcement, FBI agents are used to being cross-examined and used to being their work product analyzed, they would be better at what they do. The fact of decrease in trials hurts the whole system. People, police, prosecutors, agencies hide things. So that's a problem.
How has COVID changed prosecution of criminal cases?
Say it again.
How has COVID changed prosecution of criminal cases or the criminal justice system in general, let's say?
Well, everything came to a halt. It is kind of interesting. There are even fewer trials, it seems to me. I don't know the actual numbers, but there were no trials during COVID. I had one trial during COVID in the Southern District of New York. The entire large courtroom was used to spread the jurors around, so they weren't even sitting next to each other. Everybody was wearing masks. I couldn't understand what the prosecutor was saying half the time. People were mumbling. And there was a plastic booth from which the lawyers questioned witnesses in another plastic booth. It was pretty silly.
You mentioned a few minutes ago that people ask you how you sleep at night. What do you answer?
It's tough sometimes. It's a very, very stressful profession to be a criminal defense lawyer in the United States, particularly if you care. It's very hard work. It's very demanding. It's very stressful. The strategic decisions are life-altering. And so, it's still a worry sometimes that I do lose sleep over cases and are stressed out with family and so on.
How important is it for our society to not only protect but encourage lawyers to represent, let's say, unpopular criminal defendants?
It's crucial. I mean, we have to have a system where everybody is treated fairly and justly. I mean, I've been involved for many years on an advisory board at the Innocence Project. Friends of mine, Barry Scheck and Peter Neufeld, started that a long time ago and have proved beyond any doubt that there is massive prosecutorial misconduct There's very much, a lot of unfairness in the system. Defendants, are just not on an equal level with prosecutors. A lot of cases are lost because the defense lawyers are not properly trained or funded. They don't have investigators. I mean, we have hundreds of innocent people, proven innocent, who have served many, many years in jail. I mean, that is eye-opening. And of course, this was the product of DNA, so it's scientific proof of innocence. But they don't take many cases without DNA evidence. So cases that don't have DNA can't be examined in the same way. If they could, I believe there would be tens of thousands of more cases of innocent people being proven innocent and being exonerated.
There are several interviews of you online with Charlie Rose. You had a whole big head of curly hair during the O.J. Simpson murder trial.
Yeah.
What impact do you think that trial had on the justice system? And more broadly, are cameras in the courtroom a good idea?
I don't think that case really had an impact in terms of changing the system in any way. It was sui generis, as they say. It was all about OJ and his celebrity. But the second half of your question was what?
Are cameras in the courtroom a good idea?
Cameras. I testified in the legislature against having cameras in the court unless the defendant consents. It's the defendant whose life is on the line. There are many reasons that cameras could hurt a case. Witnesses could be intimidated. People don't come forward. You get a different sense of things when there are cameras. Jurors are intimidated. Jurors don't want to serve. There's all kinds of effects of cameras in the courtroom that are subtle, which is why the defense bar, which I was leading at the time, opposed cameras. And I say okay if the defendant says okay. But if the defendant, for some reason, refuses to go along with it, I think that should be respected.
You've tried your fair share of high-profile cases, noteworthy cases. Are defendants involved in those kinds of cases at a disadvantage or at an advantage?
Well, I would say some of my high-profile cases never would have been prosecuted except for the fact that the defendant was high-profile. So sometimes they are disadvantaged in that way. Sometimes, there's an interest in the case that gives the defendant a fairer chance. It's very much to do with the facts of the case and the support that the defendants may have, by the public. I mean, the Chicago 8 had a lot of support. They were leaders of the anti-war and civil rights movement. They had resources. There were protests. And ultimately, the Seventh Circuit Court of Appeals reversed the convictions, and the government was afraid to retry them. So it all depends on, the facts of the case. My Black Panther clients, the opposite was true. Everybody was against them. Fortunately, the jury in the Panther 21 saw it another way, and everybody was acquitted.
There's always been in this country a difficult relationship between the justice system and the press. As a defense lawyer, how do you deal with the press in cases where its impact will be felt in one way or another?
So, it's a very difficult question. And I think lawyers who take the position, I'm not going to deal with the press, potentially hurt their clients. Particularly in a high-profile case, I think that defense lawyers have to be very aware of what the press's role could be, what it is being. It could be very prejudicial to the defendant, and it could be helpful to the defendant. To me, I speak to the press, always off the record, unless I'm certain that I want something with me on the record. But by and large, in every case that I've tried where there's press involved, and that probably 20, 30 cases, I speak to the press and I want to know where they're going. And I try to help my client in ways that would be beneficial with the press. Not doing so could be really unethical behavior by the defense to take the position, I, under no circumstances, are going to talk to the press, could really hurt your client. And so, it's a complicated question.
How has social media over the past decade or so complicated that discussion?
Well, the worst thing about social media is that it is one of the factors that has led to less trials, because text messages tell stories in ways that witnesses never could. And so there could be smoking gun emails, text messages, posts on media. So it's one of the factors that has strongly affected the criminal justice system.
Is there a presumption of guilt in media-heavy cases?
No question. And that's why the defense lawyer has to be attuned to putting out a theory of the defense in many of these cases where the press is sort of obligated to repeat every time they say something about the case. If you haven't said anything and the defense theory of the prosecution and the defense isn't there, you're hurting your client.
Are legal mechanisms such as jury sequestration, venue changes, are these useful? Are these practical these days?
I had a very high profile case. The prosecutor was somebody named Rudolph Giuliani. He was the United States attorney. And his leaks about the case, besides his press conferences announcing the indictment, was so bad that the defense took polls of the public, and unbelievable, like 95% of the public heard about the case. And out of those, like 98% thought the defendants were guilty. So we moved the case to Connecticut out of the New York media just to have a chance. Sometimes a change of venue because of press is very valuable. But the press could be very, very important in a case and could determine everything. And usually the press is hostile to the defendant.
What is your general view on all these Trump prosecutions?
Well, while the Manhattan DA's case was complicated, and I think Trump has a reasonably good appeal, it was an important case to break. Because the fact of the matter is, if Stormy Daniels' story had been out and in the public, in addition to you could grab their whatever anytime you want, which was 2 weeks earlier, the election was very close. It could have affected the election. Trump could have lost because of that Stormy Daniels story. Women voters are crucial. They vote more than men. Their views are obviously very important. And so I think it was a prosecution that should have been brought. It is complicated. One of the things that sort of strikes you is while the jury had to be unanimous in finding that there was intent to falsify business records, they did not have to be unanimous if the purpose was to violate federal election law or tax law. They didn't have to be unanimous about that. That's going to be a strong issue in the appellate courts.
There's a big point as to the judge's instructions to the jury. How important are those at trial?
Well, in a case like that, it's very important because it's very complicated, and the jurors obviously wanted the instructions redone. almost immediately. New York is a place where the instructions are not sent into the jury room. There are reasons for that I could defend, but the fact of the matter is they were crucial, and so crucial that the jurors wanted to hear it right away, and they had to hear the whole jury charge again. Jury instructions, depending on the case, could be crucial, and they're often crucial in the appeal stage, because an improper instruction more likely to result in a reversal than just about anything else.
Where do you see the other trials going? Do you see them happening prior to the election? And if so, how close can the courts get to that without there being some rebellious nature in the public, let's say?
Well, there's only one trial that's one case that's pending that has a chance of going to trial before the election, and that's the January 6th prosecution in front of Judge Chutkan in the DC District Court. Because the others, Georgia is in la la land. It's a gigantic case. It's paused while it's determined whether the prosecutor should be removed, whether the prosecutor has a conflict, and the documents case in Florida is hopelessly delayed by Trump's judge, who's already shown bias. That's bizarre, yet she still presides. So it's only the January 6th case. And while Trump claims that everything is rigged, the fact of the matter, his rigged Supreme Court is delaying decision on whether he has immunity. And obviously, if they decide he has no immunity, Judge Chutkan could schedule it for trial. But when will they decide? When is it possible to go forward? That's the only one that has a shot.
In that Georgia case, there were several lawyers indicted, Giuliani, John Eastman, a few others, I think. Is it scary for a criminal defense lawyer to think that representing a client, strategizing, coming up with creative theories, which is the job of a defense lawyer, can be criminalized? Or was this such a unique case where the conduct was so outlandish that it shouldn't be surprising?
Well, I mean, clearly they were intending to do things that violate the law. I mean, these indictments in Arizona and Michigan, for phony electors and lying on forms and so on, it was all part of a scheme to overturn the election. I mean, what could be more important than trying to prosecute that? I mean, this was an attempted coup.
How do you view gag orders?
Well, again, if it's a high-profile case, the media is usually against the charged defendant, and gag orders could be very harmful. A friend of mine in Las Vegas, his client was indicted for corruption, and on the day of the indictment, he held a press conference accusing the FBI of the setup and etc. And it never made another comment. And something like 6 or 8 months later, the case was tried, and he was brought up on charges being unethical and saying all those things on the day of, the indictment. Well, there has to be a period of time where the defense could put forth its theory of the case, if it chooses to do so, in the face of negative publicity that is all generated by a prosecutorial press conference and an indictment. And, there has to be a time when the defense, can respond. Now, the closer you are to trial, it is inappropriate for either side to be commenting. And so I would advocate, and did advocate, on behalf of the Bar Association, the City Bar Association, in a committee I chaired years ago called what was the name of the committee? Oh, I forget the name of it. It's a criminal justice committee Criminal Advocacy Committee. And we came up with a proposed rule about commenting on cases. And it was essentially to prevent comments that could really affect the jury selection. And so the closer you are to trial, the more dangerous it is to have both sides comment.
Mr. Lefcourt, I'll let you go on this. A few weeks ago, Harvey Weinstein's New York conviction was overturned. Were you surprised, or was it something that you saw coming?
I am surprised, but it is so right on. I have to disclose that I represented Harvey for the first 3 weeks. We couldn't get along, and so I had to withdraw. Essentially, he was in California, I was in New York, and every night I was on the phone until my wife was going crazy. But it's so right, that decision. I mean, you know, when you're indicted for something that you're accused of doing, the trial should be about that, not about how many witnesses you could get to allege other misconduct that you're never charged with, that were never litigated. It's so prejudicial that finally the New York courts have seen it. And hopefully that will reverse a trend which has been allowing all kinds of, you know, similar act cases, you know, uncharged criminal conduct to come into a defendant's prosecution.
Mr. Lefcourt, I appreciate your time. I know it's valuable. Thank you so much.
All right. Nice chatting with you.